So, the next topic that we're going to start is justification of torts. What does that essentially mean? It essentially means that an act which will otherwise be considered as in a case of tort, but because of these specific rules, of immunity, there is no liability. So tort would nonetheless exist, had it not been for the immunity, that exists. So those are essentially justification for tort. So Sir Frederick Pollock said the rules of immunity which limit the rules of liability. Those are justifications in tort. So there are various conditions which, when present, will prevent an act from being wrongful, which in their absence would be a wrong. So justification essentially means that yes, those acts will otherwise be considered as wrong, but because of the presence of these justifications, will not be considered as wrong. And so yes, the most important case for us would be that of acts of state. Now state has sovereign powers. So and the thing is this, that acts of state as a defense is not available as against the subjects of the state or an alien friend who's residing within the territories of the state. Now acts of state as a justification for tort would be available as against people who are beyond the borders of the state or another sovereign. So if a wrong of that sort arises, what will then be the case? Well, there are international platforms where the matters can be taken up. But can those matters be taken up within the domestic courts of a particular country? Well, that does not, it does not work like that. So yes, that's what essentially the case is with respect to act of state. Now, act of state could be pre-sanctioned in the sense that this act was already sanctioned by the state, or it could also be that some act which has been done by a private party is subsequently ratified by the state. In either of these cases, act of state will be a justification. But remember, this act of state as a justification is not applicable to the case of citizens or foreign citizens who are living within the limits of the state. So Lord Atkin had said this, made this observation. He said the phrase act of state is capable of being misunderstood as applied to an act of sovereign power directed against another sovereign power or the subjects of another sovereign power, not owing temporary allegiance in pursuance of sovereign rights of waging war or maintenance of peace on the high seas or abroad. It may give rise to no legal remedy, but as applied to the acts of executive directed to subjects within the territorial jurisdiction, it has no special meaning and can give no immunity from the jurisdiction of the court to inquire into the legality of the act. So essentially what is being said is that when the sovereign is pitted against another sovereign or subjects of another sovereign, then you can say that this is a matter of act of state. In such case, you have international institutions to take resort to. But can the matter be tried within the, decided within the domestic courts? That's not what happens. But when we say that, we have to keep in mind that act of state as a justification is not available, as I said earlier, to citizens who are of that particular country or someone who's residing within the territory of that particular country. So this is the observation which has been made. Now what is the status of this as a justification in case of India? In India as well, we have this same thing. Act of state, any sovereign state will not accept a matter being brought before another within the jurisdiction of a domestic court. That's not how it works. But then, um, as I said, okay, that's something that you will see being accepted almost everywhere. But then, as I said earlier, the said defense or the said justification is not available even in case of India as against the citizens. Okay, so for example, if an executive does anything, unless it has some statutory justification, okay, for the said act, okay, if it causes civil wrong to someone, some individual, that individual can definitely take the matter to the court. Okay, so yes, the state does not have absolute immunity as against its like own citizens. Okay, it can be made liable and taken before the court and also made liable. As you know, Article 300 of the Constitution refers to that. Okay, so yes, act of state is not a justification as against the citizens or anyone residing within the territory. This was held in this famous case by the name which is Madhav, Maharaja Dhira Madhav Rao Scindia versus Union of India. It was held, I quote, that an act of state is not available against the citizen, okay, against a citizen. An act of state is a sovereign act which is neither grounded on law nor does it pretend to be so. It was described by, the said judge is saying, okay, by me, quoting from Fletcher Moulton in L.J. Salomon, Secretary of State for India, as a catastrophic change constituting a new departure, okay, in the state of Saurashtra versus Menon Haji Ismail. I have not been able to better that expression. I further pointed out that in civil commotion or even in war or peace, the state cannot act catastrophically outside the ordinary law, and there is legal remedy for its wrongful acts against its own subjects, even a friendly alien within the state. So, in a fancy way of saying the same thing, so state does not have absolute immunity for acts as against the citizens or even alien friend residing within the state. So even during, for example, warfare, okay, military vehicles are flying, okay, and in the course of that, okay, for example, or while the vehicles are moving, one of the employees take a detour and end up hurting someone. There's a possibility of liability being imposed. Okay, even in those cases. Besides that, as you know, executives. Executive officials are to function within the statutory limits. If they go beyond that and cause civil action, cause a harm or damage to you, then there's a cause of action available to you. So that's essentially the idea when it comes to acts of state. Okay, so acts of state is only available as a justification only against another sovereign. So why is that? It's essentially that Austinian definition of sovereign that we refer to quite often. A determinate human superior, not in the habit of paying obedience to a like superior, okay, which is probably another sovereign. So we consider sovereigns to be equal, okay. So a violation of a right cannot be then taken before a court of another sovereign. It has to be some other court, exists at a different level. So you will have institutions at the international level for things like that. Okay. Now, unless, for example, there are certain specific treaties entered into by the court. Okay. In such case, there will always be exceptions. Okay. Other than that, this is the rule. Okay. So, but act of state, just remember, is not a justification as against own citizen or friendly alien within the state. Okay, so that's the case of act of state. Now, what about judicial acts? Okay, now judges under the English law are not liable for things done or words uttered, acts done or words uttered while they are dispensing their duty, okay, in their judicial capacity, okay. But judges personally can definitely be liable for civil wrong that they might commit. But whatever they do in their judicial capacity enjoys, okay, certain immunities. Okay, so what about that in case of India? In India, we are following more or less the same rule, okay, but we have something called Judicial Officers Protection Act 1850, and there is another more recent act, Judges Protection Act 1985, essentially enlarging the protection. So under this act, no judge, magistrate, justice of peace, collector, or other person acting judicially can be sued in any court for any act done by him in the discharge of his judicial duty. So it's not merely who we traditionally understand as judge, okay? It could be any specific, position of adjudicator created under a particular law, whatever it is, okay? They will enjoy the protection of this act. So it further says, okay, can be sued in any court for any act done by him in discharge of his judicial duties. Remember, in discharge of judicial duty, okay, not in their personal capacity, whether or not within the limits of his jurisdiction, provided that he at the time in good faith believed himself to have jurisdiction to do the act complained of. So sometimes it's possible for judges to miscalculate as to whether they have the jurisdiction. So because of that miscalculation, the judges will not be subjected to liability. Okay, if he thought that it was within his jurisdiction in good faith, okay, believed himself to have jurisdiction to do the act complained of. Further says, similarly, no officer of any court or other person bound to execute the lawful warrants, okay, or orders of any such judge, magistrate, justice of peace, collector, or other person acting judicially can be sued in any civil court any court for the protection of any warrant or order which he would be bound to execute if within the jurisdiction of the person issuing the same. So quite often, the judgments or orders of court are implemented not by the judges only, but certain other officials. Okay, so if they are doing their duty in following the orders of the judges, okay, or anyone of that nature, as we have just mentioned, okay, which they are bound to execute, okay, orders which they are bound to execute, okay, if they were within the jurisdiction of the person issuing the said order, then even they will enjoy the immunity. Okay, so and this act protects judges and some other and various other officials as mentioned. Okay, so yes, that's the immunity which is available to judges. Okay, now the thing is this, that when judges act in their personal capacity, okay, in that case, okay, judges are human beings, they are humans. Okay, now in their personal capacity, if they indulge in any tortuous activity, then will the justification be available then? No, it is not. Okay, they have to be acting in their judicial capacity in good faith. Okay, now it is possible that judges are capable of doing something in their judicial capacity, but suppose they did it with some kind of malice, okay, that will not make it a wrong, okay, if what they did was within their judicial capacity. Okay, so that's essentially the case. Now okay, so regarding what is the implication of this particular act and the provisions of this act, okay, and what kind of immunity it creates, an important case is there by the name Anwar Hussain versus Ajay Kumar, AIR 1965. And it laid down in quite great detail as to what the implication of this immunity, the immunities are. So it says, if an act done or ordered to be done by judicial officer in discharge of his judicial duties is within the limits of his jurisdiction, he is protected whether or not he has discharged those duties erroneously, irregularly, or even illegally, or without believing in good faith that he had jurisdiction to do the act complained of. So why is this broad protection available to judges? Now imagine if a judge, okay, had to be constantly under the fear that if I adjudicate the matter in this way, then certain liabilities will be imposed. How can you expect them to freely adjudicate? So because of that, this broad, immunity has been created. Okay, so it is applicable. Okay, he's protected. Okay, whether or not he has discharged those duties erroneously. So it's possible, human error. Judges are humans. Okay, they can make mistakes. Okay, irregularly or even illegally. When it says that illegally, so not in accordance with the law, or without believing in good faith that he had jurisdiction to do the act complained of, so long the act is within the judicial capacity. Okay, that immunity is available to the judges. Essentially, the idea, as I told you, is to provide some kind of protection, immunity to the judges. Okay, so that so this is something that evolved from the common law, and now it has been enacted in the form of law. And it says such protections were also available to juries. Okay, so yes, number 2, it says if such an act, okay, is without the limits of the officer's jurisdiction. So sometimes it could be beyond the jurisdiction of the officer. He is protected if at the time of doing or ordering it, he in good faith believe himself to have the jurisdiction or to order it. So sometimes judges can also make mistakes with respect to whether he or she had the jurisdiction or not. Okay, if it is a mistake of that sort, then of course, okay. But if it is deliberate, then obviously the said immunity will not be available. Thirdly, the expression jurisdiction in section 1 of the act does not mean the power to do or order the act impugned, but generally the authority of the judicial officer to act in the matter. Fourthly, the act protects judicial officer only when he is acting in his judicial capacity, not in any other capacity. So as I told you, maybe they perform acts in their ministerial capacity. Okay, it's separate. Okay, maybe in their personal capacity, that's separate. Immunity is available only when they are acting in their judicial capacity. And fifthly, if a judicial officer arrests a person recklessly and maliciously, not in discharge of the duties of his office as a magistrate, but on the ground that he had acted under the direction of his superior officer, he can be said to be acting in an executive capacity and not in a judicial capacity, and therefore is not protected under the act. So as I said, the same, sometimes a judge might also be functioning in certain executive capacity, so making arrest under the order of a superior. In such case, the said immunity will not be available to the said judge if he acts maliciously, for example, or recklessly. So that's how it has been interpreted. Further, judges are also protected under Judges Protection Act 1985, okay, which essentially increases the protection which are available to the judge. Okay, so under this, the term judge is very widely defined, okay, to mean not only every person who is officially designed as a judge, okay, but also every person who is empowered by law to give any legal proceeding a definitive judgment. Okay, not just those who are defined as designed as designated as judges. Okay, or a judgment which, if confirmed by other authority, would be definitive. Okay, so that's the case. And then B, who is one of a body of persons, which body of persons is empowered by law to give judgment, as is referred to in a clause, okay, in clause A. So anyone who's in adjudicative capacity, okay, under a particular law as well, they will enjoy this particular immunity. So yes, someone might have been some adjudicative position. So for example, tribunals, etc., will also come under the exception in this under this particular law. So yes, so a very broad immunity has been created in favor of judges. Okay, not only in their judicial but also official capacity. So what if something has affected your rights? So what would you do in such situations? So you might apply to a higher court, okay, so high court or the Supreme Court, okay, or even to the government if your rights are violated in such case. So it's not as if you are left without remedy, but not not the usual remedy that you will claim before a ordinary court. So yes, so that's essentially what the immunities are of judges. Okay, so apart from that, executives are there, executive branches are there. So what about their acts? Okay, acts by the executive. So it's simple. As we discussed earlier, act of state does not apply as against, okay, as a defense, okay, as a justification, does not apply as against the citizens or person, alien friends residing within the territory. Okay, so executive does not have, blanket or absolute, immunity. So yes, unless their acts are authorized under a particular statute, okay, they do not have any immunity, and one can take such officials before the court. Okay, then there are administrative acts. Okay, so officials sometimes take action against their inferior officials. Okay, so in those cases, okay, when they take action, it seems to be some kind of judicial action that they take. But that is not really judicial. We say that is kind of quasi judicial action. Okay, act. Okay. But in if it is of administrative nature, so if it is an administrative act, then principles of natural justice have to be, adhered to. And, anyone acting in their administrative capacity will not have the, immunity available to judges and other officials. So if an administrative official taking any action, okay, he or she has to do the same, keeping in mind principles of natural justice. So yes, that's what that's where we conclude for today. In the next class, we will be discussing about certain other immunities, certain other defenses, or certain other justification for tort. So we have few more that we will deal comprehensively in the subsequent classes. Thank you for today.